pantau nih, Bu.
Enggak, karena dia pakai baju. Itu tuh, selamat datang. Ayo cepetan.
Dokter Dokter tadi Sudrajat SHM. Dokter tadi Sudrajat. Vice Dean, not Dean. Vice Dean. Bu, tahu.
Fakultas Hukum merupakan salah satu fakultas yang ada di Universitas Jenderal Sudirman. Perguruan tinggi negeri ini terletak di Kota Purwokerto, Jawa Tengah. Lokasinya yang strategis membuatnya mudah diakses dengan berbagai moda transportasi. Fakultas Hukum pertama kali diinisiasi melalui Surat Keputusan Rektor tahun 1979. Ide pendirian ini didasarkan pada kebutuhan masyarakat Banyumas agar dapat mengakses program studi sarjana hukum tanpa harus merantau ke kota besar lainnya. Inisiasi ini ditindaklanjuti melalui surat kawat tanggal 13 Mei 1981 dan berhasil disetujui melalui keputusan Presiden nomor 50.
Assalamualaikum warahmatullahi wabarakatuh.
Fakultas Hukum.
Shalom, Om Swastiastu, Namo Buddhaya, best wishes to all of us. Good morning, ladies and gentlemen, and also to our respected guest. Welcome to the general lecture of Ukraine versus Russia War and International Criminal Court. My name is Nabila Aulia Ginanti, and I'm here with my partner today, Oki.
My name is Oki Imanikbar. We feel beyond honor and delighted to be the master of ceremony for today's agenda. With all due respect, I welcome the respectable Vice Dean of Faculty of Law, Jenderal Sudirman University, Dr. Teddy Sudrajat, SHMH.
Honorable, the Coordinator of International Undergraduate Program, Faculty of Law, Jenderal Sudirman University. Dr. Aryani Yulianti Ningsih, SHMH.
Honorable Mr. Farid Mohassan, PhD, as the keynote speaker for today's general lecture. And Ms. Wisma Ningsih, SHMH, as the moderator for today's agenda. And to you all, our guests in this room, thank you all for coming. First of all, let us praise the Almighty Allah Subhanahu wa Ta'ala. Because of His blessing, we are able to attend this event without any obstacles.
Ladies and gentlemen, let us start this agenda with prayer according to our respective religions and beliefs. And for those who are Muslim, let us say Basmalah together.
Bismillahirrahmanirrahim.
Before we start the event, I'd like to inform today's agenda. The first is opening.
The second is singing to our national anthem, Indonesia Raya.
The third is opening prayers.
The fourth is greeting speeches.
The fifth is appreciation giving and photo session.
And the sixth is general lecture by Mr. Farid Mohassan, PhD.
And the last is the closing.
Ladies and gentlemen, we've come to the second agenda, singing to our national anthem, Indonesia Raya. For all participants in this room, please stand up to sing the national anthem, Indonesia Raya.
Thank you very much. You may all sit back in your seat. Moving to the next agenda, which is the opening prayer. To Mr. Hermawan Prasojo, SHMH, you may lead the prayer.
Assalamualaikum warahmatullahi wabarakatuh. I will lead the dua in Islamic religion and in Bahasa. Ladies and gentlemen, kindly yes. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Hamdan syakirin, hamdan na'imin, hamdan yuafi ni'amahu wa yukafi'u mazidah. Ya Rabbana lakal hamdu kama yanbaghi li jalali wajhika wa adhimi sultanik. Allahumma salli wa sallim ala sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Dengan menyebut namamu ya Allah yang maha pengasih lagi maha penyayang. Segala puji untukmu Tuhan seru sekalian alam. Hanya kepadamu ya Allah kami meminta dan hanya kepadamu ya Allah kami memohon pertolongan. Ya Allah yang maha pengampun lagi maha penyayang. Ampunilah segala dosa-dosa kami, dosa kedua orang tua kami, dosa para pemimpin kami, dan dosa para pahlawan yang telah gugur mendahului kami. Tetapkanlah hati kami agar selalu berada di atas jalan yang benar, jalan yang Engkau ridhoi, dan jalan yang Engkau beri petunjuk. Ya Allah yang Maha Pengasih, pada hari ini kami bertemu untuk melaksanakan kegiatan General Lecture yang diselenggarakan oleh International Undergraduate Program Fakultas Hukum Universitas Jenderal Sudirman. Berikanlah kepada kami ilmu dan pemahaman, limpahkanlah kelancaran dan juga keberkahan dalam kegiatan kami di hari ini. Hasilkanlah maksud baik kami, dan jadikanlah kegiatan ini menjadi kegiatan yang memberikan pencerahan dan manfaat bagi kami semua. Ya Allah yang Maha Agung, berikanlah kami kemudahan dan kekuatan dalam membangun negeri yang kami cintai ini, agar lebih maju. Jadikanlah negeri kami ini negeri yang bermanfaat, negeri yang berkah, negeri yang sehat lahir dan batin, yang rakyatnya sejahtera, adil dan makmur. Ya Allah, kabulkanlah doa dan permohonan kami. Rabbana taqabbal minna innaka antas sami'ul alim wa tub alaina innaka antat tawwabur rahim. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina adzaban nar. Subhana rabbika rabbil izzati amma yasifun wa salamun alal mursalin walhamdulillahi rabbil alamin. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you to Mr. Hermawan Prasojo, SHMH.
Ladies and gentlemen, the following agenda is greeting speeches. For the first speech, will be delivered by Dr. Aryuni Yuliantiningsih, SHMH, as the coordinator of International Undergraduate Program of Jenderal Sudirman University. To Dr. Aryuni Yuliantiningsih, SHMH, the floor is yours.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. First of all, we praise to Allah because today we can gather in this event in good health. Honorable the Vice First Dean, Dr. Teddy Sudrajat, SHMH, Dr. Farid Muhammad Hasan as a speaker, and my colleague, Dr. Hasmi Rusli from University Sains Islam Malaysia. Honorable to our respected guests from our partner universities and all participants. Ladies and gentlemen, in 2021 and 2022, we invited Dr. Farid to be guest lecturer in international law course through online platform. And Alhamdulillah, today we can meet face to face in this room and we'll learn and discuss the interesting topic of Ukraine and versus Russia war and the International Criminal Court. On behalf of the head of committee, I would like to express my appreciation to all committee for their good cooperation and so we can hold this event. We apologize if in organizing this event, they still think that's inconvenience. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you for the speeches, Dr. Aryuni Yuliantiningsih, SHMH.
For the second speech, will be delivered by the Vice Dean Faculty of Law, Jenderal Sudirman University, to also officially open the general lecture event of Ukraine versus Russia War and International Criminal Court. Dear Dr. Teddy Sudrajat, SHMH, the floor is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Peace be to the peace and God blessing be to you all. Good morning for everyone. Our respected speakers, Dr. Farid Muhammad Hasan, and Dr. Hasmi Rusli, Senior Lecturer, Faculty of Syariah and Law, University Sains Islam Malaysia, USIM. Our respected Dr. Aryuni Yulianti Ningsih as a Coordinator of International Undergraduate Programs, Bu Wisma Ningsih as Moderator, all of the committee, and our beloved student of International Undergraduate Program, Bachelor Program, Faculty of Law, University of Jenderal Sudirman. First of all praise be to Allah for His grace and guidance so that we can gather in this place and discuss an interesting international issue regarding Russian and Ukrainian war. This is an up-to-date issue that we can learn from Dr. Farid. And the second one, it is an honor for us, for the Faculty of Law, to have a guest from USIM Malaysia who are willing to present knowledge in the general lecture at the Faculty of Law Unsud. So this is the forms of international cooperations between Unsud and USIM. And we hope that it has an impact on improving quality both for Unsud and USIM. And because of that, as leaders, as the Vice Dean of the Faculty of Law, we support the activity that can provide benefit for the development of legal science. And we hope that we will have a fruitful discussion relating with the up-to-date issue regarding with the international law issue. Apart from that, we also hope that the discussion offer can provide complete pictures of this legal problem, and we can draw common traits and solutions to be able to act in these global conditions. And we appreciate for the coordinator of International Undergrad Program that can give the opportunity for the student, international undergrad students, to study more about the global context in the perspective of law science. To follow up the request from the committee by saying Bismillahirrahmanirrahim, General Lecture International Law, Issue of Ukraine versus Russia Law and International Criminal Court on Tuesday, June 6, 2023, I officially declare it open, and hopefully it can provide scientific benefit for all parties. Thank you very much. Wabillahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Thank you to Dr. Teddy Sudrajat, SIMH, for the enlightening speech and for officially opening the seminar.
Ladies and gentlemen, the next agenda is appreciation giving and photo session. The appreciation will be given by the Vice Dean, Faculty of Law, Jenderal Sudirman University, Dr. Teddy Sudrajat, SHMH, to our keynote speaker, Mr. Farid Mohassan, PhD. Please come forward to the stage. Let us take a picture first. And for the next photo session, we would like to ask Dr. Teddy Sudrajat, SHMH, Mr. Farid Mohassan, PhD, Dr. Aryuni Yulianti Ningsih, SHMH, and Ms. Wisma Ningsih, SHMH, to come to the stage for taking photos together. For the next photo session, please for the audience to stand up because we're going to take photos together. All right, thank you so much. You may all sit back in your seat.
Ladies and gentlemen, now we come to the main agenda, which is the general lecture of Ukraine versus Russia war and international criminal court by Mr. Farid Mod Hassan, PhD, and Ms. Wismaningsih SHMH as the moderator. First thing first, we'd like to read you about the background and achievements of Ms. Wismaningsih SHMH.
Ms. Wismaningsih SHMH has completed her Bachelor of Law degree in Jenderal Sudirman University. And also, she finished her Master of International Law degree in Pajajaran University. To Ms. Wismaningsih SHMH, the floor is yours.
Oke, nggak apa-apa. Nanti bisa berdiri. Saya dimulai. Okay, thank you for the MC, Master of Ceremony, for the time giving to me. Good morning, all of the participants. The Honorable Dr. Farid Muhammad Hassan and Bapak Dr. Muhammad Hasmi Muhammad Rusli, the Honorable Coordinator of IUP, Dr. Aryani Yuliantiningsih SHMH, the college's lecturers of Faculty of Law, UNSUD, and the students as participants of this general lecture. Thank you Allah for the blessing that we can hear to follow the general lecture with Pak Farid. I can call you Pak Farid, yeah? Okay. The theme of this, our general lecture today is Ukraine versus Russia war and the ICC, or International Criminal Court. As we know that from the last 2022, Russia attacked Ukraine as the Ukraine versus Russia war, and it is interesting because lately the ICC issued or enacted the arrest warrant to Ukraine, especially for the leader of the Ukraine, President Vladimir Putin, to be arrested. And interestingly, that the president of the Russia, or Russia itself, is one of the state of the member of United Nations Security Council. And I think that the Russia state itself is not the only one of the alleged breach of law, international law, because there is China to be maybe alleged breach of the international law. So before the general lecture today, I would like to read to the CV of Pak Farid from University Science Islam Malaysia, USIM. Full name is Muhammad Hassan Farid. Date of birth 13 May 1986, and scientific qualification is Doctor of Philosophy in Law, PhD. Major is International Criminal Law, International Criminal Justice System, with great excellent. It's very good. And name of institution is School of Law, University of Aberdeen, Scotland, United Kingdom. And for the bachelor is from Faculty of Sharia and Law, University Science Islam Malaysia, USIM, with the subject is comparative law and Sharia and law. And then for the master of Pak Farid has graduated from Ahmad Ibrahim Kuliah of Laws, International Islamic University Malaysia, IIUM. Teaching focus is IHL, or International Humanitarian Law, Mode, Legal Method, and Public International Law. And topic of the research are International Criminal Law, International Criminal Justice, IHL, or International Humanitarian Law, Law of Treaties, Public of International Law, Constitutional Law for Southeast Asian countries. I think those are a lot of topics of research. And then work experience. Pak Farid had to be the guest lecturer in Public Law and Human Rights Seminar Series 2022 at the University of Stirling, Scotland, UK. Visiting lecturer, Faculty of Law and International Relations, University Sultan Zainal Abidin, Malaysia at 2021. And as judge, oral submission for the Philip C. Jessup International Law Court Competition, World Championship 2021, and another sessions of court competitions. And I have read the CV of Pak Farid that Pak Farid had to be the judge of Philip C. Jessup International Law Court competitions. And I think we have to appreciate him because maybe we can learn from Pak Farid to learn about the court competition. And then publications, book, the title of the book is Statehood, a Legal Overview with Hisham Hanapi et al., 2019. And book chapters, Statut Rom, Gugat Kuasa Agong in Muhammad Hasmi Muhammad Rusli et al., Komentar Isu-Isu Antarbangsa, Perspektif Malaysia, 2019. And Farid Muhammad Hassan and Muhammad Hasmi Muhammad Rusli, Seeking Justice for the Rohingya, Will the ICC Work, in Muhammad Hasmi Muhammad Rusli and Amalina Ahmad Tajuddin, Selected Commentaries on International Law 2018. And I think there are a lot of, or the variety of articles on the journals, articles of journals. Okay, not for long comments from me. Here is Pak Farid, Dr. Muhammad Hassan Farid from USIM, University Science Islam Malaysia. The floor is yours.
Can I use the...
Please.
Sudah. Tes. Right. Right. First of all, I would like to thank Dr. Ayuni for inviting me and to be here physically after 2 years of been teaching public international law at the faculty because of COVID-19 pandemic. And this is actually my first time being here physically at Purwokerto. So I had a beautiful ride when I arrived at the airport in Yogyakarta yesterday.
and I had a ride via train to Purwokerto for 2.5 hours, and finally I have arrived at this beautiful place, Purwokerto, and it's really a beautiful place, and the campus is really nice, right? And I would like also to thank to the Dean of Faculty of Law, the Vice Dean, and also the Madam Moderator, and all the students for having me to share my little knowledge on international law. So as requested by Dr. Aryuni, that I will be handling 2 lectures for this session. So this morning session, I will be dealing and discussing on the issue of the limelight of the world that we are facing today is between Russia and the Ukraine regarding the war and also the arrest warrant, like Madam Moderator has rightly mentioned, that the International Criminal Court has issued an arrest warrant against the Russian president, and we will discuss on how and whether this arrest warrant will be executed by the international community or not. Now, before I begin my lecture, so allow me to briefly introduce myself, and as introduced by Madam Moderator earlier, so I will just skip some slides regarding my right. So as explained by Madam Moderator earlier, that I obtained my first degree from Islamic Science University of Malaysia in 2011. And then I went to Ahmad Ibrahim Kuliah of Law in 2013. So I obtained my master's degree in 2013. And then I went to the UK for my PhD. And I obtained my PhD in International Criminal Law from School of Law, United Kingdom. So this is basically the cover page of my thesis regarding the Rome Statute of the International Criminal Court. Right. The area of specializations or research interest would be on international criminal law, international criminal justice system, IHL, law of treaties, and also general public international law. During my undergraduate studies, so I used to be in your seats before, so I was a debater and a mooter myself during my undergraduate studies. So I involved in a number of debating and mooting competitions. So I involved in Arabic, English, and Malay debate championships. I went to New Delhi for my internship. And I teach a number of law subjects. So one of them is public international law and also moot subjects. So mooting and public international law are 2 subjects which are really close to my heart. Right? So if you step my body, so you will not see any blood spilled, but instead international law. So I've been here as visiting professor for 3 times already, so including this year. So I started to teach at the faculty since 2021, and then also last year and this year. So I'm very honored to be invited physically to come to the faculty. Now, I had an opportunity to be involved with the state of Palestine regarding the war crimes committed against the Palestinian brothers in Palestine, where the embassy of the state of Palestine, together with one NGO in Malaysia, invited me to be one of the legal teams to prepare a written submission to be submitted before the International Criminal Court for the ICC, or the International Criminal Court, to decide whether or not the ICC has jurisdiction over the war crimes and crime against humanity committed against the Palestinians. And on 5th February 2021, my apologies, 2022, the ICC decided that the ICC actually indeed has jurisdiction over the crimes, right? So if we may just go to the main slides, or may I control over there?
Slide. Slide.
Right, so the title for my public lecture would be on the issue of international criminal law, particularly on the Ukraine-Russian war. Now, when we discuss about law, then we have to discuss also on the history, because history and law are intertwined. Because of history, then law has been developed since then. Right, so basically international criminal law has developed since the outbreak of the First and the Second World War. Now, regarding the First World War, which took place on 28 July 1914 until 11 November 1918, there were two parties involved during the First World War, i.e. the Allied and Associate Powers, with the combination of the UK, the US, France, Japan, and Italy against the Central Powers, represented by the German Empire, the Ottoman Empire, the Austria-Hungary, and also Bulgaria. So these two parties went to war, and then various crimes had been committed, particularly on the issue of war crimes. All right, so right after the outbreak of the First World War, two tribunals were established by the international community called the Turkish Military Tribunal, which was located in Turkey, in Istanbul at that time. And also there was a tribunal or a court established pursuant to a Versailles Peace Treaty in 1919 by the Allied world powers to prosecute the alleged war criminals who have committed war crimes during the First World War. And before these two tribunals, supposedly the head of state of the Ottoman Empire at that time, Sultan Mehmed VI, was supposed to be prosecuted before the Turkish Military Tribunal, or the TMT, pursuant to these two provisions, Articles 227 and also Article 228 of the Versailles Peace Treaty 1919. However, because the tribunal was established in Turkey at that time, the constitution of the Ottoman Empire accorded the Ottoman Empire Sultan with an immunity before any court established in Turkey. So as such, the Sultan of the Ottoman Empire at that time was never been prosecuted before the Turkish military tribunal, but instead other officials have been prosecuted before the tribunals. Now, the Prime Minister and also the Minister of War were prosecuted before the Turkish military tribunal instead, in lieu of the position of the Sultan Mehmed VI before the Turkish military tribunal. And as for the court in Leipzig, or in Germany, supposedly, if you can see here, the then German, okay, thank you. The then German head of state at that time, Emperor William II, was the head of state of Germany at that time, was supposed to be prosecuted for the crimes committed by the subordinates during the First World War. However, Emperor William II ran away and took refuge in the Netherlands, so he was never been found and was never been prosecuted before the court. However, many other German leaders were prosecuted instead in his position. Now, after the establishment of the first and the second dia lambat. Ke belakang mana? Ini ke belakang. Tapi saya ketik. Ini next. Okay, ini ke belakang. Okay. Now, as for the Second World War, it took place between 1939 until 1945, where we have seen catastrophic events, where the biggest world war took place between these years, where three major international crimes were committed at this time, where crime against humanity, war crimes, and also crime against peace or crime of aggression were committed. And because of the victors during the Second World War, they won the Second World War, they have established two international military tribunals. One is located in Nuremberg, called the International Military Tribunal, the IMT, and the second one is the International Military Tribunal for the Far East, located in Tokyo. So these two international military tribunals were established in order to prosecute the Nazi Germans and also the Japanese military for committing war crimes, crime against humanity, and crime of aggression during the Second World War. Now, at that time, Adolf Hitler, who was the head of state of the German Empire, was supposed to be prosecuted before the International Military Tribunal. However, he committed suicide. So he was never been prosecuted. After he committed suicide, Admiral Dönitz took his position as the head of state of Germany, and also other German leaders were prosecuted before the International Military Tribunal for the crimes committed by the German Nazis during the Second World War. As for the Far Eastern Tribunal, Emperor Hirohito of Japan was also supposed to be prosecuted before the International Military Tribunal for the Far East. However, Commander-in-Chief of the US Army at that time, General MacArthur, decided not to prosecute Emperor Hirohito because of the occupation of the US military in Japan at the time. So this was because if the US was to prosecute Emperor Hirohito at that time, then it will make the US occupation at that time in a very difficult position. So as such, Emperor Hirohito was never been prosecuted because General MacArthur, as the supreme commander of the Allied forces, being the supreme prosecutor for the International Military Tribunal, decided not to prosecute Emperor Hirohito. But we can see here that many Japanese leaders, including the 3 prime ministers of Japan, ministers of wars, and other officials of the Japanese Empire, have been prosecuted before the International Military Tribunal for the Far East. Now, these 2 world wars, World War I and World War II, have developed and contributed to the establishment of the international criminal law. So that is why when we talk about international criminal law, then we have to go back to the history, because from those moments or from those historic moments, then international criminal law has been developed. Now, right after the commission of the Second World War, then various courts and also international community decided to declare, and also by the pronouncement of various international courts' decision, that certain crimes have been declared to be jus cogent crimes, whereby these crimes are being prohibited by the international community from being committed worldwide. So when we talk about international crimes, there are various crimes that cannot be prosecuted because of the nature of the crime themselves, right? Whereby some crimes are so universal and considered as hostis humani generi. This is a Latin word which is translated to enemies of all mankind, and also delicta iure gentium, i.e. international crimes. So because of the nature of these crimes, which are so destructive to the international community, as such, whosoever found the perpetrators of international crimes may exercise jurisdiction over the perpetrators. Now, if we can see here on the list of the crimes which have been considered as jus cogent crimes, whereby all these crimes are prohibited from being committed worldwide. Number 1 is genocide. Number 2 is crime against humanity. And then war crimes, piracy. This is piracy in sea piracy. It's not piracy cetak rompak that you copy any movies and put it in CD, right? Slavery and slave-related practices, torture, and also prohibition of the use of armed force. So nowadays it is known as the crime of aggression. So all these 7 crimes have been considered as jus cogent crimes. So these crimes have been prohibited by the international community in any ways. Now, after the end of Second World War, then after the establishment of the United Nations, the international community have gathered together and discussed to incorporate a treaty called the Genocide Convention in 1948. So under Article 6 of the Genocide Convention 1948, it clearly stipulates that, which I have put in the yellow highlighted portion of the provision, where it mentioned that International Penal Tribunal, as may have jurisdiction, may exercise jurisdiction over the crime of genocide. However, right after the establishment of the Genocide Convention, there was never any international penal tribunal ever established at the international level to exercise jurisdiction over the crime of genocide. All right. Now, as we have seen earlier on the 2 occasions of the First and Second World War, that various heads of state have never been prosecuted before any of those tribunals which I have mentioned earlier. This is because of the issue of immunity of the head of state. Now, I would like to highlight on the issue of immunity of the head of state under international law, because we will also be discussing on the issue of the arrest warrant issued by the International Criminal Court against the Russian president, i.e. the Russian head of state. Whether the Russian head of state may be arrested by the international community and to be surrendered before the International Criminal Court. Now, before I delve into that particular discussion, so allow me to at least briefly expose all of you to the substantive law under international law on the immunity of the head of state accorded by international law to the head of state. And this also includes today the head of state of Indonesia, President Jokowi. Now, basically, under international law, head of state or Ketua Negara is considered as the state itself. So if we talk about head of state or president or the king or the queen of a state, we are talking about the head itself. If we talk about President Jokowi, for example, we are talking about the state of Indonesia. We are talking about the Republic of Indonesia itself, right? So because these two notions of head of state and also the state itself are intertwined. It's like a coin, right? So if you twist the other side of the coin, it's still within the same coin. Now, under international law, head of state and state have been seen as one entity. And if state has immunity under international law, so does the head of state. So under international law, there are two types of immunity. Number one is called immunity ratione personae, and number two, ratione materiae, which I will be dwelling and discuss all these two types of immunity thereafter. Now, the issue of immunity of a head of state has become customary international law, where it is known to all countries in the world that head of state has indeed immunity. If you watch any movies or online or in Netflix and so on, you can see that head of state, right? If they are in the state of war, if a state sent an ambassador to another state, so this ambassador will never be killed, will never be harmed. That is because of the nature of customary international law, which accorded the representative of state to be considered as the state itself. So this customary rule of immunity accorded to the head of state is now enshrined under the Vienna Convention on Diplomatic Relations 1961, whereby under the two provisions of the VCDR or the Vienna Convention of on Diplomatic Relations, under Articles 29 and 31, it mentions that the diplomats, together with his or her family, are accorded with immunity under international law. And these individuals, the diplomats together with the family members, shall enjoy inviolability under international law and shall not be subject to any arrest and shall enjoy an absolute immunity from criminal prosecution. If later on in the future you become an ambassador of the Republic of Indonesia and you become a representative and an ambassador to any countries in the world, international law under the Vienna Convention on Diplomatic Relations will accord you with such immunity that you cannot be arrested, that you cannot be prosecuted. So this is customary international law. Now, this customary rule of immunity accorded to the head of state has been discussed by two International Court of Justice cases. Number one is before the ICJ in the case concerning the arrest warrant of 11 April 2000, which I will be discussing this case later on. And number two, on mutual assistance in criminal matters between Djibouti and France in the year of 2008, where the ICJ in two cases have ruled that diplomats shall enjoy immunity. All right? Now, when we talk about diplomats, because the VCDR only accords immunity to diplomats, i.e. to the ambassadors. Now, if the ambassadors have immunity, then the head of state themselves should have immunity more than the ambassadors. So that is why the ICJ in these two cases decided that the application of the Vienna Convention on Diplomatic Relations should also be extended to state high-ranking officials. So the question is now, who are these state high-ranking officials? Now, international law has developed since then, whereby state high-ranking officials have been interpreted by the court to include these three individuals. Number one, the head of state, or ketua negara. All right, regardless who is the head of state, whether it is the president of a state, or the king, or the queen. Number two is the head of government. All right, so this applies to a state where its legal system provides the head of state and also the head of government for two different individuals. All right, such as in Malaysia, because in Malaysia we have the king as the head of state and the prime minister as the head of government. But like in Indonesia, you have President Jokowi as both the head of state and also the head of government. Right? And lastly, the Minister of Foreign Affairs, or Menteri Luar Negeri. These three individuals have immunity under international law from being arrested and from being prosecuted before any courts for any crimes whatsoever if he or she is still in the office as the Prime Minister, the head of state, and also as the Minister of Foreign Affairs. Right? In other words, if President Jokowi is still in office as the president of this country, President Jokowi will have immunity and he shall enjoy absolute immunity from the arrest and also from criminal prosecution under international law. Now, as catastrophic events have took place during the First and Second World War, where we can see that many empires use this immunity as to evade prosecutions and arrests under international law. So that is why international law has made sure that those who are responsible for the commission of international crimes must face justice. As such, international community and particularly international law has decided to make sure that those who bear greatest responsibility shall face justice and shall split two types of immunity under international law so that those who have committed international crimes will be prosecuted. Now, there are two types of immunity under international law. Number one is immunity ratione personae. Number two is ratione materiae. As for ratione materiae, it applies to those heads of state, i.e. the president or the prime minister or the foreign minister, when he or she is still in power, i.e. where he or she is still in office as the heads of state. So long as he or she is still sitting as the heads of state of a country, he or she shall enjoy absolute immunity under international law, all right, for whatever crimes. So if he or she travels all around the world, he or she cannot be arrested for whatever crimes. However, once the office has ceased, for example, in Indonesia, President Jokowi's term cease after 2 terms or after 1 term, and then whether he or she, President Jokowi will be re-elected or not. So it depends on the winning of the election. Let's say President Jokowi has not win the election, so he will cease his office. So after he has ceased his office, then he shall no longer enjoy immunity ratione personae. So right after the heads of state cease his or her office as the heads of state, then immunity ratione materiae will take over. However, this type of immunity has condition that immunity ratione materiae will only protect the former heads of state for any actions which fall within the category of official acts and official conducts only. If the former heads of state have done something outside the scope of official conducts, then immunity ratione materiae will not protect the former heads of state. As such, the former heads of state may be arrested and may be surrendered to the to any courts, including international tribunals. And these has been incorporated and discussed by the ICJ in the case of diplomatic and consular staff case between Iran and also the United States of America in the year of 1980. Now, the issue is that what constitutes official acts of former heads of state while the former heads of state are in office. Now, the threshold whether certain acts are constituted as official acts or not must be decided based on case-by-case basis. All right, so we have to look at the facts of the case. Now, there are a number of cases which have been decided by various national and international courts regarding the issue of immunity. Now, number one is in relation to the issue, to the case of the former Chilean president Augustus Pinochet. So, when Augustus Pinochet was the head of state of Chile, so he had committed the crime of torture, where he had tortured thousands of Chilean civilians during his presidency, right, during his premiership between 1973 until 1990. So when he is no longer became the president of Chile, right, so under international law, supposedly immunity rational material will protect Augustus Pinochet. Now, when he fell into sick, right, after he was no longer became the president of Chile, he traveled to the UK, right, for medical treatment. So when he arrived in London, so he was arrested by the police forces in London for the crime of torture that he had committed during his presidency between 33 years and so. So when he was arrested, all right, in London, he argued that he cannot be arrested by the UK authorities because he has immunity under international law, being the former president of Chile at that time. So this case was brought up to the House of Lords or the Supreme Court in England to decide whether he actually has immunity under international law from being arrested by the UK authorities. So the House of Lords in the UK decided that since he had committed torture during his time as the president of Chile, the crime of torture has not been considered as official acts of being a president of a country. As such, he is not being protected under immunity rational persona, being the former president of Chile. Okay? And this has become one of the landmark case for the court at the international level and also national level to decide on the fate of former heads of state after he or she has ceased his or her office being the heads of state. So, and the House of Lords at that time decided that, you know, he can be arrested and he can face criminal charges for committing torture. So, however, he died in the prison before the prosecution took place. Right? So he was never been prosecuted. Now, there's also a case before the international, at the international level, where heads of states have been prosecuted. So as I have highlighted earlier just now, that various tribunals have been established to prosecute various heads of state, right? But however, we have seen that Adolf Hitler was never been prosecuted before because he had committed suicide. Emperor Hirohito was never been prosecuted because General MacArthur decided not to prosecute him. But however, other heads of state have been prosecuted instead. Now, I would like to highlight one of the leading case as decided by the International Court of Justice in relation to immunity of a Minister of Foreign Affairs. So there was a case brought before the ICJ in the year of 2002 in the case of arrest warrant, all right, between the Democratic Republic of Congo or the DRC and also Belgium in 2002. Now, what happened in this case was that the foreign minister of of the DRC at that time, he had made a speech in the DRC where in his speech he has incited genocide in the DRC. So right after he has given his speech in the DRC, genocide took place. Thousands of people have been killed right after he has made his speech. Right? Because of his speech, thousands of civilian, innocent people have died. Right? So because of that, Belgium took an initiative, right? Because genocide is an international crime. So Belgium decided to exercise jurisdiction over the foreign minister of the DRC, His Excellency Abdoulaye Yirodia Ndombossi. So he was the then foreign minister. So at the time when the crime was committed, he was still the foreign minister of the DRC. So Belgium went to the magistrates' courts in Belgium for the magistrates' courts to issue an arrest warrant against Minister of Foreign Affairs of the DRC, Minister Yirodia. So because of that, the magistrates' courts in Belgium issued an international warrant arrest against Mr. Yirodia. So the Democratic Republic of Congo contested on the arrest warrant issued by Belgium because the DRC argued that Mr. Yirodia, as the sitting foreign minister, has immunity from any arrest under international law. So the DRC contested on the arrest warrant issued by Belgium. So this case was brought to the ICJ for the ICJ to decide whether Mr. Yirodia has actually immunity under international law or not. Now, when the case was brought to the ICJ decided that Belgium's arrest warrant was void and was illegal under international law because it was issued against a sitting head of state of the DRC. Because under international law and also under customary international law, a sitting head of state cannot be arrested. So as such, the arrest warrant issued by Belgium is void and is illegal under international law. However, the ICJ mentioned that the sitting head of state can only be arrested if he or she falls into the 4 categories. So what are these 4 categories? The ICJ made an exceptions for heads of state who are still in office to be arrested and to be prosecuted before any courts.
Sorry to interrupt, Pak Farid.
Yes.
But your time is until 10:45, so you have still 15 minutes
Sure.
to present your slide. Thank you.
Sure. All right. So under international law, the ICJ mentioned that one of the exception provided is that the sitting head of state can only be arrested if he or she is to be tried before a competent international courts. Now, I would like to relate with the issue at hand that we would like to discuss in relation to the topic to be discussed today, relating to the issue of the arrest warrant issued by the International Criminal Court. Now, the ICC has been established in 2002 pursuant to a treaty called the Rome Statute of the International Criminal Court. Now, currently, there are 120 states which are parties to the ICC. So the ICC has 4 jurisdictions. Number 1 is on genocide. Number 2 is on crime against humanity. Thirdly is on war crimes and the crime of aggression. Now, there are conditions for the ICC to exercise its jurisdiction. That the crime must be committed on the territory of a state. And number 2, it must be committed by a nationals of a state. So these are the 2 preconditions of the ICC to exercise jurisdiction, right? And now the ICC can only act as the court of last resort, which means that national states or national courts must first exercise jurisdiction over the 4 crimes mentioned earlier. So failure to do so, then the ICC will take over the case. Now, under the Rome Statute, particularly under Article 27, it mentions that immunity of the head of state shall not bar the ICC from exercising its jurisdiction. Now, in relation to the issue of Ukraine and Russia, I would like to highlight on the trigger mechanisms of the ICC jurisdiction, where the ICC jurisdiction can only be triggered within these four situations. Number one, if a state party to the Rome Statute refer the case to the ICC themselves. Number two, if the case has been referred to the ICC by the UN Security Council. Number three, by the referral made by the ICC prosecutor. And lastly, by a non-state party on an ad hoc basis. Now, as rightly mentioned by our Madam Moderator just now, that Russia is one of the permanent members of the Security Council, and it is highly unlikely that the case to be referred to the ICC by the UN Security Council. As such, the only possible way for the case to be brought up to the ICC is by the ICC prosecutor proprio motu investigations, or by the initiative of the ICC prosecutor. Now, the Russian-Ukraine war. Now, I would like to highlight this, that both Ukraine and Russia were actually non-state parties to the Rome Statute from the beginning. However, Ukraine has become a state party to the Rome Statute after since 2015. Now, so one of the parties to the conflict is not a state party to the Rome Statute, i.e., the state of Russia. Now, this is the map where the crime took place in the Ukraine, whereby if you can see on the red color of the portion of the territory, that the state of Russia has invaded the territories of the Ukraine and took over and controlled these the four territories as highlighted in red color. Now, on 17 March 2023, last 2 or 3 months, that the ICC has issued an arrest warrant against 2 individuals for the alleged war crimes committed against the Ukrainians. Number one is against the Russian president or the Russian head of state, and number two against Maria Alexeyeva Lvova-Belova, right? Who is the Commissioner for Children's Rights in the office of the Russian president. So I would like to highlight on the arrest warrant against the Russian president. Now, so this arrest warrant has been issued by the ICC against the Russian president is because of the war crimes for unlawfully deportation of children population in the Ukrainian territory for the war crimes committed. So because of that, the ICC issued an arrest warrant against the Russian president. Now, this is actually the same issue that the international community has faced previously, particularly on the arrest warrant against the Sudanese president. Now, in 2005, the Security Council has referred the genocide case in Darfur, Sudan, to the International Criminal Court, particularly against the president of Sudan, right, pursuant to Resolution 1593, whereby the situation in Darfur shall be referred to the ICC for criminal prosecution. Now, what happened in this case was that 2 arrest warrants have been issued by the ICC, right, in 2009 and also 2010. So being a member state to the African Union decided that the African Union will not execute the arrest warrant issued by the ICC because the African countries decided that the case should have been first decided by the African courts. However, the Security Council refused to do so and refused to allow domestic investigations or domestic prosecutions to be made in Africa. So as such, the case shall be proceeded before the International Criminal Court. And because of that, the African Union dissatisfied and then decided not to execute the arrest warrant issued by the ICC. So because of that, when the Sudanese president visited various African countries, right after 2 arrest warrants have been issued by the ICC against him, he was never been arrested under international law, especially when he visited South Africa for the African Summit in 2015 before. All right, so South Africa is actually a state party to the Rome Statute. Now, supposedly under international law, South Africa has the obligation to arrest and surrender the Sudanese president to the ICC. But South Africa decided not to arrest him because South Africa argued that the Sudanese president, being the head of state, shall enjoy immunity under international law. And also, being the host country for the African Summit, then they have this international agreement to accord the Sudanese president with immunity. So because of that, he was never been arrested by the South African authorities. So because of that, the ICC has decided that South Africa has failed to fulfill its obligation under the Rome Statute to arrest and surrender the Sudanese president. So I would like to skip this one and just straight away go to the arrest warrant. Now, if we watch news and televisions, that statements have been made by various news worldwide that President Putin will go once again to South Africa to attend BRICS meeting. All right, BRICS stands for Russia, India, China, South Africa, and also to discuss on the economics fate of all these 5 countries, right? So now, as we have seen that on the same situations, when the Sudanese president visited South Africa before, that the Sudanese president was never been arrested by the South African authorities. So now, the Russian president once again would like to visit the same country. Now the issue would be that whether South Africa will arrest the Russian president when he visits South Africa in this coming August to attend BRICS meeting. Right? So now, if we can also read from the news that the state of South Africa plans to change the law in South Africa in order to accord the Russian president with immunity, so that when the Russian president or the President Putin visits South Africa this coming August to attend BRICS, he will not be arrested by the South African authorities. Right? Now, I would like to highlight on the issues of criticisms and the hypocrisy of the international community regarding the issuance of the arrest warrant against the Russian president. Now, as we can see that Amnesty International has issued various reports on the alleged crimes which have been committed by the Ukraine over the civilian populations because 2 countries were in the bricks of war between Ukraine and also Russia. And of course, when Russia attacked Ukraine, Ukraine will defend themselves and will also attack Russia. So when the state of Ukraine defend themselves and attack Russia, civilian casualties occurred as well. So Amnesty International has concluded in various reports that civilian casualties had actually occurred when Ukraine attacked Russia. But this never been brought up to the attention of the ICC for the ICC to also issue an arrest warrant against the Ukrainian President Zelensky. All right, so this is one of the issue that the international community has criticized widely against the ICC for being hypocrites when it comes to Russia, for issuing arrest warrant against the Russian president for the alleged war crimes committed by the Russian presidents for asking the troops to attack the Ukraine, but not to issue an arrest warrant against the Ukrainian president as well. And not only that, if we can see also from the news, as reported in many occasions, that President George W. Bush has also admitted that he was in the wrong position to wage war against Iraq when the US and also other NATO countries invaded Iraq in 2005. So, as all of you have learned in law, that if the person himself admitted the crimes, then that is actually a good committal for a crime. So why didn't the ICC also issue an arrest warrant against President George Bush for the crimes that he himself has admitted that invasion took place wrongly under international law, and no actions or no investigations or no prosecutions have taken place against George W. Bush and also his allies when invading Iraq in 2005, right? So we'd like to hear your thoughts, right? Your questions, your sides of thinking on the issue at hand, that in relation to the Ukraine and Russian war, and also the admission made by the former president of the U.S., President George W. Bush, for the Iraqi invasion in 2005, and should the ICC issue an arrest warrant against him, including all his allies during his time, including Tony Blair of the UK. So with that, I thank you, and I open to the floor with any Q&A. Thank you so much.
Thank you, Pak Farid, for all of your slides. And I think it is the interesting issue for us to discuss the war crimes allegedly committed by Russian President Vladimir Putin. And if I can highlight the issues of Russia versus Ukraine war and the ICC, those are interesting issues, such as that Vladimir Putin is the sitting head of state until right now, and it is opposite with the Vienna Convention on Diplomatic Relations 1961, that head of state and head of governments are have the immunities, especially criminal jurisdictions. And then Russia itself is the member of the P5 of United Nations Security Council, and I think that Russia has alleged or breach the international law, especially United Nations Charter of United Nations, Article of 2, paragraph 7, and also that for the arrest warrant itself from the ICC prosecutor, that Russia and the Presidential Commissioner of Children's Rights alleged that the two of the prosecutor is alleged what I can say, that the crime is transported or transported children from Ukraine to Russia, so that it is alleged for the international humanitarian law and international human rights law. Okay, this is the time for Q&A session, and I think before the Q&A session, I would like to welcome the guest from Win Seizu, right? The two of guests are from Universitas Islam Negeri Saifuddin Zuhri, Purwokerto. Ibu barangkali bisa disampaikan, Ibu siapa? Ibu Vivi dan Bapak Bani. Okay, thank you for your participants and your coming here. Okay, the first session for the Q&A session, maybe I would like to give the occupation for the 3 students here. Please raise your hands and
Oh, we have
those-
many questions. That's very good.
yeah, because I think it is the interesting issue, Pak Farid.
Yes, yes, indeed.
Okay, for
Please.
the first line of the student, Mas siapa? Mas Rozan. Okay, and then Mbak, the second line of the students, Mbak siapa? Syakun. Syakuntala. Oh, it
Will the
is,
students get additional marks for their participation?
Sakuntala, it is the unique name.
Yeah.
And then the backline of the students, Excel, yeah?
Excel Arya, is it? He was my past students.
Okay.
He used to be my student before.
You know Excel?
Yes, yes.
Okay.
And we follow each other in Instagram.
Okay.
Yeah.
Okay, for the first question from Rozan. Please, Rozan.
Okay, thank you moderator for the opportunity. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Good morning, Dr. Farid. First and foremost, my name is Rozan Ibn Haikal. I'm from Generation 22 International Class. First thing first, appreciation for you for the presentation, very insightful and very knowledgeable. Second thing is, the question is, what is your thought about the Ukraine and Russia war? Is it can become a factor of World War III? Regarding if we took an insight of the academic, the religion part of Islam, the World War will be caused by something greater, like an evolution. And if so, how does the International Court of Justice deal with it, and how does the United Nations comes from the conflict within the nations itself, and how does the United Nations prevent the World War III to happen, remembering the fact that World War II and World War I, it's coming from the evolution of the League of Nations. Thank you.
Okay, thank you, Rozan. And for the second question from Syakuntala, please.
Okay, my name is Syakuntala. Before, I want to say thank you, Professor Farid, for the lecture. We all know that currently war is happening between Russia and Ukraine. So I would like to know about your perspective of the biggest impact of the Russia invasion to the ASEAN countries like Indonesia and Malaysia about the international public policy and law regulation. Thank you.
Okay, thank you, Syakuntala.
In Malaysia and Indonesia, on which policy? Come.
International public policy and law regulation, the biggest impact.
Regarding
The Russian
how we view
invasion.
the war.
Your perspective.
Okay.
Okay, Pak Farid, you can get the question.
Yeah, yeah.
And the third question from Excel, please.
All right. Thank you so much. And it's really nice to meet you in person, Mr. Farid. My name is Axelara Pratama. I'm from International Law Undergraduate Program, 2020. So I would like to ask, or maybe I have like an opinion that the resolution for Russian Federation itself is a bullshit. I guess I'm so sorry for my language, because the first one, I think that Russia is the part of P5 countries. So Russia has a veto right. So all of the resolution, for example, the resolution in February 2023, is failed because it's vetoed by Russian Federation, while most of countries may be accepting the resolution. That's first. The second one, I think that Russian Federation withdrawing the Rome Statute on 2019. So ICC has no right to do the condemnation to Russian Federation. So what's actually the rational resolution to prevent or condemn the Russian act on Russian and Ukraine war? Because there are a lot of violations. For example, like the treatment of their dead war body in related to Geneva Convention and the protocols and so on and so forth. So what's the resolution can be provided, whether it's from the countries, from multilateral cooperations and so on and so forth. Thank you so much.
Okay, those are the questions from students, Pak Farid, or maybe Ibu Vivi and Pak Bani, you can give the questions for Pak Farid, or maybe later. Okay, thank you. We wait for your questions. Thank you. Okay, please, Pak Farid.
Right. Thank you so much for all these very mind-boggling questions, and these are all very good questions indeed. So let's go to the first questioner, Miss Brother Rozan. Is it Rozan? So he asked whether the Russian-Ukraine war will lead to the Third World War. So if you ask me, I'm not a shaman where I can predict what's going to happen in the future. But by judging from what is happening currently, if you ask, based on my personal opinion, whether Third World War will be into a reality, my answer would be perhaps yes and perhaps no. Now, what I would say this is that the reason why the international community, particularly the ICC, has issued an arrest warrant against the Russian president is actually to put an end to the alleged crimes from being committed by both parties. Because if one party has been stopped from doing something, the other party will also be stopped from retaliating. Right? For example, if the ICC has issued an arrest warrant against the Russian president, then the Ukraine will stop from being retaliating from the attack by Russia. So if this happens, then the Third World War can be stopped. If we do not put an end to this, then if no arrest warrant has been issued by, let's say by the ICC as a competent international tribunal, then both parties will still keep attacking each other. Then the scale of the attack will be bigger and bigger day by day. So that is why in order to prevent a greater evil from being happening, then it must be put to an end. So that is why in my view that the step which has been taken by the international community to prevent the so-called Third World War from being happening in the future is by issuing this arrest warrant is actually a good move, right? And if you ask me on the based on religion, where Islam has predicted that a great war will happen in the future, I also do not have this. What we call that, I cannot see the future. But again, coming back to the question and coming back to the earlier question, that by preventing this from being happening in a larger scale, then it might not be our time to see this great war from being happening. And I believe that you and myself will also in the position not to see this great war from being happening within our bare eyes, because when we talk about the catastrophic events in Second World War, Hiroshima and Nagasaki, the atomic bombs, right? At that time was 45 kilometers of power in 1945. Can you imagine the nuclear power that all these countries have nowadays, right? And thousands of warheads that they have, right? With just by dropping one warhead, more catastrophic event might happen. So you and myself will pray that we will never see this Third World War or the Great War during our time. Because you and I, perhaps that we cannot run away if this happened, right? And particularly on whether the UN may prevent the war. Now, as rightly has mentioned by Brother Rozan himself, that Russia is one of the permanent members to the Security Council. And as we can see from the trigger mechanisms that the ICC has, that one of the trigger mechanisms is by referring to the ICC by the UN Security Council. So since Russia is one of the permanent members to the Security Council, it is highly unlikely that the Security Council themselves will refer the situation in Ukraine and Russia to the ICC. Of course, when a draft resolution to be tabled before the Security Council to bring the case to the ICC by the Security Council under Article 13 Clause B will be vetoed by Russia. So that is why the international community has opted for other mechanism to trigger the ICC jurisdiction by asking the ICC prosecutor to initiate the investigation on proprio motu. So that is why the ICC decided to issue an arrest warrant by virtue of the request made by the ICC prosecutor. So in that way, the UN cannot play its role under the UN Charter by invoking a resolution to refer the situation to the Security Council, because Russia is one of the permanent members. But other initiatives have been taken by the international community under Article 13C and also Article 15 of the Rome Statute instead. So I hope I have addressed your concern. Right? So I would like to move to the second questioner, Ms. Shakuntala, is it? Shakuntala, all right. It's a very unique name. Right, so she asked, what was the biggest impact of the Ukraine-Russian war to the Asian countries, right? And what would be the Malaysian-Indonesian view on this war? Now, the impact of the invasion of both countries we can see on many scales and many areas, right? For example, that when we talk about war, we must also see the effects, especially on economics. I'm not an expert on economy, but we know that countries trade with each other. So if countries involve themselves in war, then trades cannot be pursued as usual. Trade must be put on stop because they must focus and focus themselves to defend themselves and also from being attacked. So trade will be halted. Not only that, we have seen that, for example, the US has decided to impose sanctions against Russia, right? That oils from Russia cannot be sold to any other countries. Many properties belong to the Russians. Well, will be put on freeze, right? So all these economic impacts, right, have close relationship with war. So my concern is on the impact of this war between Ukraine and Russia is on the economic perspective, right? Because as we all know that Russia is one of the importer of flour, for example, and any other important materials or goods to the world, right, including the Ukraine. So if this war has not been put to an end, then many countries will face the consequences in terms of the trade. Going to your second question on what would be the Malaysian-Indonesia view on this war, as we all know that many countries, not only Malaysia and Indonesia, that many countries have decided not to be seen as in a position to support any of these two parties. All right. So, for example, Malaysia and Indonesia, we are parties to ASEAN. So, under the ASEAN Charter, we have non-interference provision that we will not interfere in someone else's business. We want to be seen as fair and square. We want to be seen as not to side or not to be on any side, especially either with Ukraine or with Russia. So because this will also have impact to the image of the country and also to the impact on the economies. Because if you cite any of the parties, then the other will stop from trading or from have a good international relations with you. So then this will give impacts to the society, to the people, to you and myself, right? Being Malaysians and Indonesians. So the decisions of the ruling governments not to take side is actually a good decision, because we need to be seen as neutral. If we take side, then of course you must support in any way. Okay. So I hope that I have addressed Ms. Shakuntala's concern. Now let's move on to the last questioner, Excel Arya, that Russia has vetoed many resolutions, right, since for many years now. And Russia has withdrawn from the Rome Statute since 2015 because of the Georgian invasion and Crimean invasion, right? And he asked whether the ICC actually has a good position to refer the case to the ICC. Now, regarding the veto, we can see that the 5 members, or the 5 permanent members, have been vetoing many resolutions, not only Russia, right? Especially the US. When it comes to the fate of the Palestinian people, right, to refer the matters where the crimes have been committed by the Israeli against the Palestinians, many hundreds and thousands of draft resolutions have been vetoed by the US since then, right? So when it comes to the Russian himself, of course that when the Security Council was trying to table any draft resolution to decide on its fate, and being a permanent member to the Security Council, then Russia has the right to whether to agree with the resolution or to disagree with the resolution, right? So by invoking its veto power, we cannot say that it's an impunity on the part of Russia from doing so, right? Because Russia is just exercising its right under the UN Charter from and also to exercise its power to veto, right, when necessary. Okay? Because we have seen that in many occasions that Russia also support many occasions where resolutions to be adopted by the Security Council has been supported or have been supported by Russia in many occasions, including to refer the case of Sudan, including to refer the case of Libya to the ICC, and also to the resolution to be adopted by the Security Council for the issue of Palestine to be heard at an international level. Now, whether Russia, being a non-state party to the Rome Statute, whether the ICC has the right to refer the matter, the answer is yes. All right. So as I have mentioned earlier, that there are 4 types of mechanisms where the ICC jurisdiction can be triggered. So one of them is by the referral made by the Security Council. So since you have mentioned that Russia is one of the Security Council member, then Russia will highly likely to veto to any resolution to refer itself to the ICC. So resolution to refer the matter to be adopted by the Security Council will definitely be vetoed by Russia. So we also have other alternatives to refer the matter, i.e. by proprium motu investigation by the ICC prosecutor to the ICC. So this is what has been done thus far, where the international community has reported to the ICC prosecutor to take charge for the matter and to refer the case to the ICC. So that is why the ICC prosecutor took the initiative to ask the ICC pretrial chamber to issue an arrest warrant against the the Russian president. So this is the trigger mechanism that has been provided under the Rome Statute, whether the state is not a state party to the Rome Statute or not. Okay? And whether the resolutions can be adopted on various violations of other treaties like the Geneva Conventions and so on. Now, under the Rome Statute, various important instruments of international law, such as the Geneva Conventions 1949, have been incorporated directly and indirectly under the Rome Statute, particularly on the war crimes under Article 8. Right? So it is not the 4 or the 7 documents of the Geneva Conventions 1949 and also the 3 additional protocols which are separate from the Rome Statute. But all these important instruments have been codified, right, on its major provisions into the Rome Statute. So when we talk about war crimes, not only the Geneva Conventions and the 3 additional protocols, but also other various international treaties have been also incorporated under the Rome Statute, right? So with that, hope I have answered Brother Axelaria's questions. Thank you.
Okay, thank you, Pak Farid. And it is the interesting comment from Pak Farid that he's not a shaman and all of us. So that we cannot predict that the war of Russia and Ukraine will be the third world war, because we are not shaman. Only Zelensky and Putin and all, of course, God know where the war can go.
Indeed.
Okay, right. Okay, thank you for the third student, the 3 students of the Faculty of Law. And then for the next term of the Q&A session, please welcome to the 3 students for the questions. Please. Okay, at the back lines, Abdurrahman, right? Or Muammar? Muammar. Muammar, it is, he is the student from Yemen.
كيف الحال؟
Okay, Muammar, and then? Oh, and he is the friends of Muammar, Abdurrahman, right? Abdurrahman.
Abdurrahman. أنت من وين؟ من اليمن أيضا.
So, where is the third? Hamza. Hamza, you will not ask the questions? Okay. Muammar, and then Abdurrahman, and then the third student for the questions, please. Who will be the third student for the, okay, the name, please? Alif. Alif Alauddin. Okay, please, Muammar. Muammar, please give your
Hello,
question.
Assalamu alaikum. We are thanks for your explain. I'm Muammar Muhammad Abdullah from Yemen. I'm from Class International. My question it is about what's happened in the Middle West from Palestine until before 2 months. It's what happened in Sudan. So why the international law is not have individualized decision position in the crime in the Middle West, like the crime of Bashar Assad. It will happen in Syria. It's the war in Syria. It's still for I think for 13 years to all the kills, and some cities like the floor. And the second question, to what's happened in Ukraine for 2 years, and why the United States or the Finto help to don't have individual position to stop the war. And I think if it's a thing to third war, and if the international law have any ability to stop any global war. Okay, and thanks.
Okay.
Yeah, shukran.
That's all. Okay, Pak Farid, maybe you can get the question. Pak Farid, you can speak Arabic?
Little bit, شوية.
Maybe for the next, Abdurrahman, you can speak Arabic with Pak Farid.
But it's better to ask the question in English, right? أنا أتكلم لغة عربية شوية.
My name is Abdurrahman from Yemen. My question is, how does the International Criminal Court determine or impose its jurisdiction or authority in its in these cases like Ukraine or Russia or Sudan like this? Thank you.
I cannot get the questions. Maybe
if
you.
I heard your question correctly, you have asked how the ICC may impose jurisdiction against Russia and Ukraine. Is it? Is that the question?
How can international criminal court impose or determine its authority or jurisdiction in these cases?
Maybe the question is how can ICC determine the jurisdiction of the crimes for the Korean. And then the third question from Alif Alauddin, please.
Thank you, everyone. My name is Alif Alauddin. For Mr. Farid and everyone, I would like to hear your statement regarding following my statement. ICC is about to punish the Russian government and even order the capture of President of Russia, Vladimir Putin, for what have they done to Ukraine, but they did not fully punish everyone who was involved in the war of Afghanistan and Iraq war, especially former President USA George W. Bush, who was the one who initiated the invasion of Iraq and left hundreds and thousands of casualties during the war, according to some reports. George W. Bush and everyone who involved, including former UK Prime Minister Tony Blair, who supported the invasion during the Iraq war, must be arrested as well. It is fair, right? Putin arrested for invasion of Ukraine, and George W. Bush arrested for invasion of Iraq. Thank you.
Okay, those are the 3 questions from the students, please, Mak Farid.
Right. In relation to the first question by Brother Muhammad or Muammar?
Muammar.
Now he was asking on the crimes being committed in the Middle East, right? Particularly in Palestine and in Syria. I would like to share what happened in the state of Palestine, because I involved in the case in Palestine, where I have prepared a submission to be submitted to the ICC for the ICC to determine whether the ICC has actually jurisdiction over the alleged war crimes and crime against humanity committed by the Israelis against the Palestinians. So last 2 years, the ICC has decided that it has jurisdiction. So the ICC, if you open up the ICC website, the ICC is now conducting preliminary investigations on who should be charged and for what specific charge or charges, right, and against whom these charges to be done or to be made against, right, so that criminal investigations and prosecutions can take place, right? So because it's a matter of evidence, right? So the ICC has decided in 2021, on 5th February, that it has jurisdiction over the crimes committed on 3 Palestinian territories, on West Bank, East Jerusalem, and Gaza. So whatever crimes committed right after the state of Palestine has been considered as a state in the eyes of international law since 2012 until today, and according to the ICC decision, that the decision will take place after the ICC, after Palestine has accepted its jurisdiction on 31st December 2014 and onwards. So it is not the crimes being committed after the state of, or the apartheid state of Israel was established since 1948, because the ICC only established in 2002, and it only commences jurisdiction since 2002. So whatever crimes being committed before the establishment of the ICC will not exercise jurisdiction. And in relation to the Syrian war, right, the Security Council has attempted to refer the situation in Syria to the ICC for many times. However, these draft resolutions have been vetoed by both China and Russia for many times. So as we all know that being permanent members of the Security Council, even if one permanent member veto any draft resolution, that draft resolution cannot be adopted. So in the case of Syria, not one, but two permanent members to the Security Councils have vetoed the draft resolutions to refer the situation in Syria to the ICC. Therefore, that draft resolutions cannot be adopted, and to refer the matter to the ICC by the Security Council cannot be done, right? But this is also one of the criticisms received by the ICC from the International Committee for being one-sided, because if Security Council cannot refer the matter in Syria to the ICC by Security Council, the same goes to the issue between Russia and Ukraine, because Russia is one of the permanent members to the Security Council. So the Security Council cannot refer the situation in Ukraine and Russia to the ICC, but instead via the ICC prosecutor proprio motu investigations. Why didn't we invoke the same way for the issue or for the case in Syria to be referred to the ICC instead? All right, so that is one of the criticisms raised by the International Committee with regard to Syria, right, for that matter, right? And you have asked on the Ukraine-Russia war, where there is no resolution adopted to stop the war. And I have commented on Axel Arias' questions and also your other colleagues earlier, that Russia is one of the permanent members to the Security Council. So Russia has vetoed draft resolutions to condemn the war or the attacks committed by Russia against the Ukraine. So that is why we can see that no resolution has ever been adopted by the Security Council thus far, right? So I hope that I have addressed Brother Muammar's questions. Now, coming back to Mr. Abdul Rahman's question on what basis that the ICC can impose jurisdiction against Russia and Ukraine. So as I mentioned earlier, that there are 4 ways for the ICC to exercise its jurisdiction. One of them is via the referral made by the ICC prosecutor. But this ICC prosecutor initiative must be consented by the ICC pre-trial chambers. So, as we have seen earlier, that the ICC pre-trial chamber has issued an arrest warrant against the Russian president. So, by virtue of this arrest warrant, it clearly shows and indicates that the ICC pre-trial chamber has agreed, upon request made by the ICC prosecutor, to refer the matter to the ICC, not via the UN Security Council referral, or not by the referral made by the state party itself to the ICC. Right? So I hope that I have addressed your first question. Now, regarding the jurisdiction, how we are the ICC will determine on what crimes on the jurisdiction. Normally, after the person has been arrested, right, or not, then preliminary investigations will be conducted by the ICC prosecutor to determine on specific charges, right? Because evidence must be gathered in order for someone to be charged for whatever crimes. And now we know that what are the specific charges to be imposed against the Russian president, i.e. on the illegal transfer of children population from the Ukrainian territory to the territory of Russia. So that is the charges. So we have, the ICC prosecutor has also gathered evidence in also to prosecute the Russian president before the ICC. But even if the evidence are there, but still, the fact that the Russian president cannot be arrested and surrendered before the ICC to physically face the criminal charges before the ICC, any criminal charges cannot also be done by the ICC, because the ICC cannot charge someone in absentia, i.e. the person to be charged must physically appear before the court. So he or she cannot be invisible, cannot be somewhere else in any part of the world without physically facing the criminal charges and answer to all the charges before the court. Right? Hope I have answered your queries. And the last questioner from Brother Arif Alauddin, and he rightly read the statement that the US has admitted on the war crimes committed in the Iraqi invasion in 2005. And Tony Blair should also be brought together to face criminal charges before the ICC. Why didn't all these charges have been brought to the ICC thus far? So that is also one of the criticisms that I also agree with you, that George W. Bush, Tony Blair, and whosoever align with these two very important individuals for the Iraqi invasions to face criminal charges before the ICC. But if you can see now that the ICC prosecutor is led by the British, i.e. Prosecutor Karim Khan. He is a British and he's from the UK. How could a citizen of the UK refer the matter or refer the then Prime Minister of the UK to the ICC? That's number one. Number two, if the case to be referred to the ICC by the Security Council, the UK again has the veto power to veto such resolution to refer the matter to the ICC, right? And the UK will never refer itself to the ICC under Article 13, Clause 1. So this is highly unlikely to take place. The only way is that it must be referred to the ICC by the ICC prosecutor, like the ICC prosecutor is doing against Russia. But again, the current ICC prosecutor is from the UK. So it is highly unlikely the citizens of the UK will refer its own former Prime Minister to be referred to the ICC and to face criminal charges. So these are the critics of the ICC that has been received by the international community on whether the ICC can be seen as to be not to take side on any countries. But this has been proven, right, on the equations of Iraqi invasions thus far, right? And I hope that I have addressed Brother Arif Alauddin's questions. Thank you.
Okay, thank you. That is the long explanation from Pak Farid. And I think it is very ironic that Russia, as the member of P5 United Nations Security Council, that the United Nations Security Council has the primary responsibility to maintain international peace and security. But as a matter of fact, the Russia itself break the law by invade the Ukraine. So the Russia has breached the peace and security of world. But I think there is still time for the next session, but not for 3 students or maybe Bu Vivi or Pak Bandi. Okay, Pak Bandi for the next session of Q&A. Please, Pak Bandi, and maybe one of the students will give the questions for Pak Farid. Okay, the student at back lines. Please, Pak Bani, for the questions. Maybe the microphone for Pak Bani.
Yeah, thank you very much. My name is Bani from Universitas Islam Negeri Purwokerto. Even though very often reading or watching international news, I have no knowledge about international law. So my question is, what is the difference between international crimes and war crimes? And in my opinion, international crime is crimes against humanity or crimes against human rights. which is done by the state to its citizen. And war crimes is crimes conducted by the state to other state. And if my opinion is true, the next question is, why is the case of Rohingya in Myanmar cannot be considered as international crime? Or can the military junta of Myanmar be prosecuted or indicted to international crimes? Thank you.
Okay, Pak Bani asked the case of Myanmar, right? Okay, the next question from the students, please.
Okay. Under the status quo right now, that Russia is a part
Puspa.
of this. Oh,
You are Puspa.
yes.
Okay.
Okay. So under the status quo that Russia is a part of Security Council, that I want to ask you, how effective do you think, or do you believe the International Court of Justice, or ICJ, has been meditating and resolving dispute between Ukraine and Russia in this context of the ongoing conflict we already in? And secondly, I would like to
Are you referring to the ICC or the ICJ?
ICG. Yes. And about that, I would like to know that your perception. Do you think that current international legal framework adequately addresses the complexity of the Ukraine and Russian war? Because I think that it's very complex right now, and there's a lot of questions related to that right now. Do you believe that there is a needed for further development of international law in this context? Thank you.
Could you repeat the last part of your question?
Do you believe there is a need for further development of international law in this context? Okay, thank you.
Okay, Pak Farid, those are the two last questions for the Q&A session, please.
Right. It is as if that I have been attacked. But it's like a viva during my PhD, so I received many questions. But it's a very intriguing questions, right? To respond, before I respond to Pak Bani, is it? Yeah. Before I respond to Pak Bani's question, I would like to respond to Madam Moderator's points that she has highlighted on the P5 members, which are supposed to maintain international peace and security, but it has done nothing because no resolution has been adopted by the P5 thus far, including the other non-permanent members. I agree with this. So this is because that many suggestions have been raised by various countries in the world that the permanent members to the Security Council must be abolished, because as long as we have the position of permanent members, then veto power will still be there. So, and under the practice of the Security Council, if any of the permanent members or the P5 veto against any draft resolution, such draft resolution cannot be adopted. So that is why, in order to exercise its power, to restore and also to maintain international peace and security, there shouldn't be any veto powers. Right? Now, in order to amend the UN Charter, right, particularly to remove and to abolish the powers of the permanent members to the Security Council, these 5 permanent members must also agree to remove such powers from themselves. So the question here is that, can we see that, or when we will see that these permanent members, the P5 members, will agree to remove such privileges accorded under the UN Charter from them? So because of this, the positions of the permanent members, by having such veto powers cannot be removed, then the veto power should be extended. Now, if 5 countries cannot exercise their work properly, to restore and also to maintain international peace and security. Because if any of the 5 veto, if we extend to any other countries, then more powers, many occasions, will never be exercised by the Security Council, because more veto will be casted by any of the permanent members after this. All right, so if you agree with me that it shouldn't be extended, but instead it should be abolished, right? Now, in response to Pak Bani's question, if I may, on the difference between international crimes and war crimes. Now, war crimes, crime against humanity are the categories of international crimes. So under international law, there are many categories of international crimes. 2 of them are war crimes and crime against humanity, right? Other than that, as I have shared with all of you in the slides before, there are 7 types of crimes which are considered as international crimes. We have genocide, we have war crimes, we have crime against humanity, we have torture, right? We have piracy, we have slavery and slave-related crimes, and also we have crime of aggression. These are the 7 categories of crimes which constitute as international crime. Now, how do we measure whether such crime is international crimes or not? The ICJ and also many tribunals have decided in many occasions that in order to determine on whether certain crimes to constitute as international crime or not, we have to look at the scale of the crimes, right? Whether such crime, the impact of the crimes impact on larger scale. Because if we talk about murder, so someone murders someone else. So the scale is not as genocide. Because genocide, there must be an ethnic cleansing. Populations must be mass killed, all right, in order to constitute genocide, instead of ordinary murder, right? And also, by looking at the practice of the international community prohibiting such crimes from being ever committed. So these are the threshold for certain crimes to be considered as international crimes or not, right? So we have to look at the threshold. Now, in relation to Rohingyas exodus, all right, why the issue or the case of the Rohingyas have not been brought to the ICC. Right? To answer this question, that the ICC now is conducting preliminary investigations on the genocide committed against the Rohingyas people in Myanmar. So it is under the investigation by the ICC prosecutor. So to say that the case of the Rohingyas has not been discharged by the ICC is not fair, because the case is in Myanmar has been listed. If you open up the ICC website, the case of Rohingya is there, is already there, right? So it's just a matter of whether the evidence are enough to bring the case, and whether the ICC prosecutor is ready to charge certain individuals. And as we all know that Aung San Suu Kyi is highly responsible for the alleged genocide committed against the Rohingyas, because it was under her leadership that genocide has been committed. Now, since she won Nobel Peace Prize before,
Aung San Suu Kyi.
Aung San Suu Kyi, and also other military leaders who are holding and held positions in Myanmar, right? And by virtue of their positions in Myanmar, that it is highly unlikely that all these individuals to be arrested by their own authorities to be surrendered to the ICC. Because under international law, especially by the ICC, we do not have an international police for that international police to go into someone else's country to arrest the suspect and to surrender him or her to the ICC. So the ICC relies heavily on state cooperation. So in this sense, if let's say the ICC prosecutor decided that Aung San Suu Kyi and also other Myanmar leaders to be charged before the ICC, as such, the Myanmar authorities must give their cooperation with the ICC to arrest and surrender all these individuals. But the question is that whether the national authorities in Myanmar would be able to arrest their own leaders to be arrested and to be surrendered to the ICC. Because if they are surrendering their head of state, if they are surrendering their head of government, it is as if that they are surrendering their sovereignty of their country to be decided by the ICC. So this is a matter of the dignity and also sovereignty of a country. All right? So that is why we have seen in many cases that cases cannot be brought up to the attention of the ICC because of the arrest and surrender, right? Because we do not have international police, right, to arrest the suspects, right? Hope I have addressed Pak Bani's question. And in relation to Sister Puspa's queries on the ICJ for not bringing the case to the, on the case of Rohingyas, you mentioned on Rohingyas just now, is it? Russia and Myanmar, is it? Russia and Ukraine, yes. Now, to bring the case to the ICJ, under the UN Charter, especially under the ICJ statute, both parties, i.e. both states, must agree to bring the case to be decided by the ICJ. If any of those countries never consent to bring the case to the ICJ, then the ICJ will never exercise its jurisdiction. Now, in this situation between the Ukraine and Russia, both Ukraine and Russia must agree to bring the case to be decided by the ICJ. For instance, because of the violation of the Genocide Convention, or because of the violation of the Geneva Conventions, for that matter. So both Russia and the Ukraine must agree to refer the case to the ICJ. But it is highly unlikely that we can see that both states would agree on the same matter so that the ICJ would decide on the case, right? So if Russia vetoed on the referral to the ICC, right, the same thing that will be done by Russia not to agree to bring the case to the ICJ to be decided. Right? So I don't see that the ICJ will exercise jurisdiction. But perhaps that in the future, after President Putin is no longer become the Russian president, and at that time the Russian president decided together with the with the Ukrainian president to agree to bring the case to the ICJ. Perhaps on that day, the case will be decided by the ICJ. And as for now, that it is highly unlikely that matter will be seen to be decided by the ICJ. Right? I hope that I have addressed your concern. Thank you.
Okay, thank you, Pak Farid. And I think all of the questions have been delivered by students, and I think this is the end of the session of Q&A because the time is past. And maybe Pak Farid, we have to give the big applause to Pak Farid. Thank you.
It is such an honor for me to share my little knowledge and also to listen to your queries and questions from all of you, because your questions might also raise some very important concerns that I might be able to prepare myself in the future should next session will rise again at any other occasions.
Thank you, Pak Farid. Maybe you can join with me here to be here.
Sure.
Here. And this is the end of the Q&A session. I would like to say thank you for all of the participants here, for the students, and for the guests from UIN Saizu, Saifuddin Zuhri, Bu Vivi, and Pak Bani, and also for the lecturer of the Faculty of Law, Universitas Jenderal Sudirman. I think maybe we can, we hope that we can meet again at the next academic activities like this one, so that we can get more knowledge, especially international law, or maybe from the other law subjects. And thank you very much for all of you, and especially for Pak Farid, Pak Muhammad Rusli, Hasmi, and maybe I will give you the pantun. Jika ada sumur di ladang, boleh kita menumpang mandi. Jika ada umur yang panjang, boleh kita berjumpa lagi. I think this is the same pantun between Malaysia and Indonesia, right? Kalau di Banyumas ya nandur jahe nenggalengan, kono bae nggo orang ngerti, nggo delengan. Okay, thank you very much. Big applause again for us. And I think that will be the next session after lunch, so that maybe you can join again for the next session with Pak Farid. This is the day of Pak Farid in Faculty of Law, Universitas Jenderal Sudirman. Maybe you have to spare your time to go around at Purwokerto City here, to go to the interesting places like Batu Raden and other interesting places. Okay, thank you, Bapak. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh. Back to the...
Thank you, Mr. Farid Morhasan, PhD, for sharing your precious knowledge with us. And thank you to Ms. Wisma Ningsih SIMH for moderating our general lecture today. We're sure that is very insightful for all of us.
As an appreciation, we would like to give a certificate for our speakers today. The certificate will be given by Dr. Ayuni as the coordinator of International Undergraduate Program of Universitas Jenderal Sudirman. Please come forward to the stage.
Thank you so much, sir, for coming.
Well, unfortunately, that marks the end of the agenda. Let us close this event by reciting Hamdalah together. Alhamdulillah.
I am Nabila Aulia Ginanti.
And I'm Oki Imanikbar. As the master of ceremony for today,
we would like to thank the audience for the participation, and we also apologize for our mistakes during the event.
We truly appreciate your time and enthusiasm for attending today's general lecture. We're hoping to see you all again in another occasion. Wassalamualaikum warahmatullahi wabarakatuh.